Let me welcome everyone to this town hall session with Judge Philip Robinson and Judge Philip Smith, who are our two domestic judges who preside over the 3rd and 4th Circuit Courts in Davidson County. The Nashville Bar Association has been hosting these town hall meetings to allow our members to hear from our judges about the changing procedures in their courtrooms following the unprecedented Supreme Court orders suspending in-person hearings and providing for other relief measures while we go through this pandemic. Welcome, Judge Robinson and Judge Smith. Thank you so much for being with us today.
Thank you.
Thank you.
Being involved.
I'd like to begin by just posing a general question to both of you and ask you to give us sort of an overview of what has changed in your courtrooms and with your procedures since the Supreme Court orders were issued.
Well, Philip, if you don't mind, I'll go ahead and take that. It's a lot of changes. And quite frankly, they change generally weekly, sometimes daily. We're doing our motion dockets either by telephone conference or video conference. The only thing we're really hearing live are orders of protection when Special Master Ballinger needs our assistance. But our technology that we have in this building and historic is dated. We're scheduled and funded to get new material, to get new equipment next year. Hopefully, we'll be able to alleviate a lot of the technical issues with the new equipment. To say that video conferences and telephone conferences are not cumbersome, I mean, it's difficult. We've run into problems this morning on my motion docket, but we are getting through it. It's taking more time. Anything that we're taking testimony on right now is by video conference. We're doing, at least in 4th Circuit, we are doing uncontested divorces on Tuesdays. We are doing those by telephone conference if the parties are with the lawyer. If not, we'll do them by video conference. We're doing TRO hearings by video conference at this point. I'm sure I've probably missed something, but we're not hearing anything contested, any contested final hearings. I'm not hearing any terminations. I've heard some uncontested adoptions via telephone and video conference, but we're not able to work at the capacity that we have until we can have in-person hearings, and I think the Supreme Court understands that.
Well, from 3rd Circuit Court's position, Judge Smith is correct. I mean, tremendous changes in the way we're dealing with things. Most of the attorneys are aware that, and we've tried to, Judge Smith and I are trying to do pretty much exactly the same thing so the lawyers don't have to learn 2 different ways of dealing with things. But we're posting our motion dockets, I think, on Mondays each week so the attorneys can look at them and see if their case is scheduled to be heard. And then we're asking the attorneys to call in to make certain we have phone numbers, and if they've settled or resolved their cases, then we take them off the docket. But then on Tuesdays, we're having uncontested irreconcilable differences, divorces. Sometimes I'll set special hearings for some matters. I've actually had some contested hearings using video conferencing. So we've, on some of our Thursday show cause dockets, we've gone ahead and had some hearings and allowed people to be cross-examined and had other witnesses join us. So we've kind of tried to experiment with it a little bit. The motion dockets are cumbersome. I have to say, Judge Smith is right. We're not as efficient. We're not getting as much done. It seems like we're still doing a lot of work, but primarily our staff are the ones doing most of the tough work. And Judge Smith and I just have to make the rulings, and sometimes it's problematic, but our staff is really going above and beyond the call of duty, trying to get all of these things ready, trying to make certain the equipment works, communicating with the lawyers. I'm hopeful, though, that in maybe, Judge Smith will correct me perhaps, we're supposed to submit plans for reopening, and I'd like to think that we can get the 20th Judicial District can get its plan submitted, and we can get permission to reopen by maybe the middle of the month. I may be being too optimistic on that, but I'm getting tired of coming into an empty courtroom. I'm used to lawyers sitting out there and looking back, and we're kind of missing them. I hope they don't get used to this being on TV, because we don't intend to keep it going if we can avoid it.
Well, I want to, Laura, briefly, I want to echo what Judge Robinson said about our staffs. Our staffs have been great to help us. This is a learning experience for everyone, and we couldn't do it without our staffs. So, thank you.
Judge Smith, I think you mentioned that Special Master Ballinger is hearing some OP matters in person. If I understood that to be the case, what sort of measures are being taken to assure social distancing in those in-person hearings?
Well, what we're doing is on the 5th floor. She hears those in Judge Haynes's old courtroom. She is only hearing one case at a time. It's my understanding that witnesses are coming in as needed, and as soon as their testimony's over, they're asked to leave the courtroom. In the hallway where most of these folks are sitting, the chairs are social, 6 feet, 6.5 feet apart. The pews, we're trying to ensure that people will social distance when they sit on the pews. Of course, people have a mind of their own. And, it's they're cleaning the courtroom between each case, wiping down the tables, the chairs, things of that nature. I don't know about the masks, but I'm sure they probably are wearing masks down there. I will tell you, I think that one requirement that the Supreme Court will have on us, that they've required every other judicial district to have so far that have opened up, is mask. The Supreme Court's pretty strict about how we're going to open up. Their ultimate, they view their ultimate obligation, as do Judge Robinson and I, as the protection of the litigants and the protection of the lawyers. We want to protect them first and foremost. We want to have courts as a place where they can come and feel comfortable and not be exposed to this horrible virus.
And that really leads into my next question. Judge Robinson mentioned when things open back up, and y'all both mentioned the plan for the 20th Judicial District that we anticipate will be submitted to the Tennessee Supreme Court for approval. What sorts of measures are you considering or suggesting as part of that plan for assuring social distancing once more and more in-person hearings are being held?
Okay. Philip, you want to take this one, or you want me to take it?
Yeah, and if you'll kind of make certain I don't leave anything out. What the goal, of course, is to keep people from spreading the virus. So and as y'all know, domestic court produces a lot of hearings and a lot of people. In fact, Judge Smith and my courts are the busiest courts in the historic courthouse, the old courthouse. Judge Kennedy's is a close third, but those three courts are all on the 6th floor, and those are the ones that generate the most traffic. On our dockets, and we're talking primarily the irreconcilable differences docket, uncontested divorce docket, the show cause docket, and the motion dockets. On those days, what we intend to do is limit the number of people that are allowed in the courtroom, allowed in the hall, and we're going to overflow to the jury assembly room on the ground floor. And so what we're going to do is we'll only have a limited number of people in the courtroom, a limited number of cases called. So an example being an uncontested divorce docket, we would perhaps call 3 cases into the courtroom, social distance everybody in the gallery area. We're going to obviously social distance the lawyers, and then deal with those cases so that those people, as soon as they get their divorce over with, can leave the courtroom, leave the building. The remaining people will be out in the hall, hopefully social distanced from one another. And if we have too many people or we need overflow, our staff will have them down in the jury assembly room. And we're going to try to do the same thing on our show cause dockets and our motion dockets. Have I left anything out, Judge Smith?
Just a couple of things I'd like to cover. One, back when when the Supreme Court entered their COVID-19 order, state trial courts here in Davidson County, we were already working on some things to do. Judge Binkley entered an order several weeks ago that prohibits anyone that has tested positive for COVID or has been exposed to COVID, someone with COVID, for the last 14 days, anyone that's traveled out of the country for the last 14 days, from entering the building. If they do, they will be escorted out. That's one of the first steps that we took. Some other things we're going to do is on the pews, benches, whatever you want to call it, we're going to mark 2 seats on the front pews. It'll probably be masking tape with a big X mark there. And that's where people are going to sit on each end. There's more than 6 feet between. But in the pew behind them, we're going to mark a seat in the middle of that pew. So, imagine kind of each person being the anchor of a triangle. That's what we're going to be looking at. We're going to alternate that through the courtroom. And we've estimated in 4th Circuit, which is a little bit bigger than 3rd Circuit, that we can probably get 17 litigants in at one time. Of course, we're accustomed to having on a Friday anywhere from 100 to 125 or more litigants in the courtroom. We're going to also move a bunch of chairs out where lawyers sit. We're going to space the chairs, 6.5 to 7 feet apart. And the number of chairs in the courtroom will be limited. Will determine the limit of lawyers that will be allowed in the courtroom. Quite frankly, we're probably not going to allow the lawyers to enter until their case is, until they enter with their clients. We're going to have to engage in the ability to clean the seats, counsel tables, the podium. We're going to have plexiglass screens installed on both podiums, each side of the podium. We're going to have plexiglass screens on the benches. That has not been done yet. We are working on that. Also, Judge Robinson talked about the hallway. Again, we're going to, on the 6th floor, we're going to go ahead and mark the benches. And the chairs are already spaced apart. We're going to try to keep it that way. And we are going to use the jury assembly room on Fridays for the spillover. It is my understanding, and Judge Robinson may correct me if I'm wrong, but I believe the jury assembly room will be used by the grand jury for 3 days a week, Tuesday, Wednesday, and Thursday. Then that is the jury assembly room in historic. We're going to stagger the motion docket times for hearings. In other words, we'll probably take 20 at 9 o'clock or after first call, maybe at 9:30, 20 at 10:30, 20 at 11, and we can always add more calls as we go through the day. We're going to encourage lawyers not to bring cheering sections with them. I know in domestic violence cases, particularly, a domestic violence victim may want to bring somebody, and I think that's in that situation probably okay. Probably not going to be able to enter the courtroom with them though. And in our domestic cases, our divorces, our custodies, things of that nature, please don't bring family members, just the people you need. If it's a motion to set, a motion for service by publication, a motion for waiver of a parenting plan, we're going to look at ways to maybe be able to address those by telephone conference, where we don't really have to have a hearing much on those. We don't have to have sworn testimony. But if you do have to appear, don't bring your client. We're trying to cut down on people entering the courthouse and the hallways. We recognize that clients do have a right to be there. We're just strongly encouraging lawyers, at least through this stretch, please bring only the folks you need. We don't need cheering sections, like I say. Let's see what else. Just judicial settlement conferences, which Special Master Oglesby and Special Master Williams do for us. We really need to get judicial settlement conferences opened up. We settle about 75% of our divorce cases and divorce-related issues in judicial settlement conferences. What we're looking at doing is having more rooms available so that maybe the special masters can just go between two rooms. Instead of bringing people out in the hallway and making them sit out there, they can stay in one courtroom all day. Of course, mask will be required. Social distancing will be required. And we're really trying to push the Supreme Court to get that opened up as soon as possible. Some things that I hope will help, will happen as a result of this is I would like to see some non-invasive temperature taken of people, anyone entering the court, right? Anyone entering either courthouse. And we know that can be done with these thermometer guns that you're not touched with. But sanitizer dispensers, we're working on those right now. I will tell you, Special Master Williams actually a few weeks ago called a distiller here in Nashville and asked if they were making hand sanitizer. And a few days later, she got a call from Jack Daniels down in Lynchburg and told her that they have 5 gallons of hand sanitizer. And of course, she had to drive to Lynchburg to pick it up. Unfortunately, she can only get hand sanitizer. I was hoping for a little black label to help us through this, but we are working on the dispensers. We've got one on the 6th floor at this point. We're hoping we'll have one to put in the elevator lobbies and at each end of the hallway. Those are some of the changes that we've been talking about. The state trial judges are going to get together, I believe, next week before the plan goes up to the Supreme Court to talk about some other general ideas that we may be able to use to keep everybody safe. And I'm sorry I rambled on so long.
Well, we've got actually a couple of follow-up questions from our audience members on the social distancing that you anticipate once more in-person hearings are being held. One question concerns using the podium. I know you mentioned cleaning it. There's a suggestion that maybe lawyers shouldn't speak from or share the podium for hearings. And the question is, what are your thoughts on that? And then let me just go ahead and ask the second question that came up, which is with the number of people allowed in the courtroom, does the rule about not having as many people maybe in the cheering section, is that going to apply to advocates?
You talking about to domestic violence advocates?
Yes.
We hadn't talked about that yet, but it may do it.
One thing in regards to the question about the podium is also going to have plastic shields on both sides of it, is my understanding. Is that your understanding, Judge Smith?
Yeah, plexiglass shields. Yeah.
And obviously my hope is that between each case, we'll have a court officer to swap the podium down where people's hands may have been. We need to keep people at the podium as far as this court's concerned, because that's where our microphones are. And as most of you know, most of Judge Smith and my hearings are video recorded. The problem is if people wander away from the microphones, then when you try to go back and look at those videos, you can't hear what they were saying. Obviously, it's always helpful for, as far as I'm concerned, for someone to be at a microphone where they're speaking good and loud so I can hear them. But even if you weren't doing that for me, we need to have you need to stay close to the microphone so we pick you up on our video recording.
One other question that's come up is once more in-person hearings resume, if a litigant or an attorney falls into a class of people who's at a higher risk, maybe because of health concerns or age, will they have an option to appear other than in person, even if maybe others involved in the case do appear in person?
You know, I think that's something we're probably going to discuss next week among the state trial court judges. That's something that I think we have to be in agreement across the board on. I'm sure some accommodation will be made for those that are in the high risk category for the period of time that we have COVID as a concern. But you know, the problems that we're running into with not having in-person hearings are a lot of exhibit issues, and you know, exhibits. You know, we're asking that lawyers before a hearing e-file exhibits, and e-filing has been great through all of this. I can't commend Mr. Rooker enough for what he's done, but I do think that we're going to have to reach a solution on dealing with exhibits, which is a problem. You know, we can require people to send them in, but as we're all trial lawyers, you know that sometimes you have to use something that maybe you didn't anticipate. So those are problems that we're running into. And, you know, we're going to have to deal with it. To answer your question is, I'm sure some accommodation will be made.
In that regard, let me say that when our video conferencing has worked, it's worked wonderfully. And as I say, I've actually been able to have some contested hearings on it. But when we have problems, it can totally end the hearing. So if we have a litigant or a crucial witness and they get on screen and then their audio goes out, or their Wi-Fi isn't broad enough for all the data to be able to be transferred, we get tiling and suddenly we may lose audio. And when that happens, if we can't reacquire them, the hearing is essentially over. And so everybody else has come up here for nothing. So as good a stopgap measure as the video conferencing and the telephonic hearings have been, it does have limitations, and all it takes is somebody to have some bad equipment, or we've been getting a lot of feedback a lot of times where as I'm speaking or perhaps asking a question or making a ruling, there's feedback after every sentence, every word I say, and it makes it hard for other people to hear. So video conferencing is great, but it's not a cure-all. It doesn't solve all the problems, and when you do have problems, you almost can't go forward. So we'll have to assess all of that.
We're getting some questions about default divorces and when you may start hearing those again, and if you're making any plans to rule on the pleadings, or if the plan is just to start hearing those once court reopens.
Phil, I know I want to be heard on this. I've been continuing all of those indefinitely, and our reason for that is that they'll, and the lawyers will know from being in our courts on Friday morning when we call that docket first. It's not unusual for a litigant who's been served but hadn't filed an answer to be there and request additional time. And it's for that reason that we're really not dealing with them. In regards to all of those motions, Judge Smith and I think have both talked about maybe having a special docket and getting a number of those set on those dockets to try to get them caught up in a couple of different special settings. Obviously, once that takes place, then the default hearing will need to be scheduled, and we may need to schedule a day where we're just doing nothing but those default divorces to try to help that get caught up. In those, and I know Fourth Circuit has tried to go forward with pro se or self-represented divorces. I've been continuing all of those because, as far as I'm concerned, the litigants have so many problems with their pleadings, their parenting plans, that it requires a fair amount of on-hand assistance by my staff, and that's exactly what we're trying to avoid with our pandemic situation. So once we are able to have in-person hearings, we'll probably also have a special docket for that, to maybe a workshop to get a lot of people up here to try to help them get their paperwork together, and then maybe some special dockets just to help self-represented litigants. Phil, do you have anything to add on that?
No, what I think our goal is, Philip, Judge Robinson and I both talked about it, is there are certain things we can catch up pretty quickly, and we would like to get those caught up. The child support cases on the 4D docket, show some of the show causes, things of that nature. We do want to get those caught up. Adoptions is one thing I want to get caught up on, and let's get those caught up pretty quickly. On the contested divorce cases or the contested domestic cases, they weren't all divorces, but we've had to continue quite a few. I think I have had to continue somewhere between 10 and 15 cases that were set, some for multi-day trials. As far as setting those, they're going to be set before anything new is set. And we're not setting anything right now until we know what the date is to open up. We do have some time this summer in Fourth Circuit. I don't know what Judge Robinson's trial schedule is, but I've even discussed with Judge Robinson and Judge Binkley of looking at some of the other civil judges, civil circuit judges, to take some of these cases to help us out. As you know, jury cases aren't going to be tried until sometime in early July. So, we're looking at all of the different options that we have to get our dockets caught up as quickly as possible.
And following up on that, obviously, we all know, everybody does domestic work. We know we need these folks that are in living in a divorce case, that we know they need to get through it as quickly as they can. So we're going to give, as Phil said, preference to resetting cases to the people that had their cases set, try to get them back on the dockets quickly. But on the other hand, we're probably going to need the lawyers to weigh in. Many of the other judges, other circuit judges, do not have backgrounds in domestic law or haven't dealt with domestic cases. So I do remember, I've been around long enough to remember there were times where all of our divorce cases were scattered around through the circuit courts. And you got a lot of very uneven rulings because we had some people that were much more experienced with domestic cases than others. So probably need the lawyers to kind of weigh in on that, give us their thoughts, whether it be they'd rather get their case heard quicker, even if they're dealing with a judge that doesn't have a background in domestic law, or is it better for the cases to take a little bit longer for us to get to, but at least be heard by judges that are more familiar with the domestic law. I'm speaking, of course, for myself. Judge Smith, I'm sure, still struggles with understanding domestic law, but I'm sure he'll catch up.
Wow.
We have a follow-up question on the ID divorces. Have you considered waiving any form of appearance on hearings for ID divorces where both parties are being represented?
I don't think we can do that, and the reason is we have so many problems with ID divorces that we have to correct that morning. If we waive the appearance, it's just going to create more problems as far as getting that divorce concluded. We'd rather be able to correct an error or a mistake or an omission that morning and let both parties initial, rather than have to send it back, once or twice to get it corrected and leave them in the marriage in the meantime. So quite frankly, I don't really see the waiver of an appearance in the future. Philip, would you like to chime in on that?
Well, and Judge Smith is sharing some of the blame for me because I know that I tend to find more problems than he does. Not that he's overlooking them. It's just that perhaps I'm kind of trying to get everything just right, and maybe I'm overdoing that. He calls me Chatty Cathy, and that it seems that I spend a lot of time on all my dockets talking. But having said that, we do find enough significant issues that if we don't have the litigants and the case is set and we're looking at it and there's a problem, we just have to continue it and the people don't get their divorce. If both parties appear, and we don't require both parties to appear, and if you don't get a call from my office saying there's a problem, it's not necessary for both parties to be here. But if we think there's a problem, we try to give you a heads up and get both parties there so we can talk about it and hopefully fix it, resolve it by making corrections and initialing it so the people can get their divorce that day. But Judge Smith is kind enough to be taking some of the blame for me. I know I tend to be a little bit of a perfectionist on things. So I apologize to the bar, but it's just the way God made me, I guess.
Judge Smith, you mentioned adoptions, and we have a question about whether or not you would consider hearing a step-parent adoption by Zoom or by telephone conference, and if not, would you consider specially setting those hearings so that those parties and their attorney may appear, and it's directed at cases that have been pending since the shutdown that are uncontested and all paperwork has been approved by the court?
Actually, adoptions are not covered under the in-person exceptions listed. I don't think I can do it in open court, but I've actually had a motion docket already during all of this, and we're going to be doing one either towards the end of the month or in early June, which certainly will either do it by telephone or by video conference. You know, again, we have to kind of prioritize things, and I don't mean to make light of adoptions. I love doing adoptions. Adoption day is the best day of the month for me. But the problem is we're dealing with a lot of other issues right now, particularly with orders of protection and TROs in emergency situations that are taking time away from the time I could give an adoption, give to an adoption docket.
Ms. Baker, one thing I was just sitting here thinking about, and I know Judge Smith and I have been doing this as we're kind of calling, we look at our motion dockets the week before, either Friday or over the weekend, the week before, and we try to prioritize those things that are short, very short matters. We're trying to deal with kind of as a first call, and then things that we think will take a little bit longer second, and the things that take the longest third. There's nothing wrong with the attorneys doing that once we reopen, because I know that driving downtown parking when you just got a motion to withdraw and there's no opposition by anybody, it'd be nice if we could figure some way to deal with that without people having to appear. It's possible that if lawyers are in agreement on things like attorneys withdrawing or their litigants have no opposition to it, and that's clearly stated in the motion, it's possible those could be dealt with either if we decide to do something by video, or at the very least, let your case be put on the early part of the docket so you can get in and get out, because the whole goal, once we reopen, is getting people in the courtroom, get their business done, and then get them not just out of the court, but out of the building so that we've got as few people in the building as possible. So I'd be interested in hearing some of the lawyers' suggestions about that.
For cases on the docket that have any kind of scheduling order or depositions that need to be taken, discovery responses that are due, how is the court handling those deadlines? The Tennessee Supreme Court order, I know, extends certain deadlines and addresses discovery. How are you handling those matters in your courts?
Well, excuse me, I think we're having to redo a lot of scheduling orders. I think this has prevented a lot of discovery from being completed, particularly in the way of depositions. And I'm readily amenable to rescheduling. And rather than come to court, if there's a problem with the scheduling order, what I strongly suggest is that the lawyers contact Special Master Williams and see if they can agree on scheduling order extensions. And if they can, go ahead and enter an agreed order on it. I'm going to approve it. You know, we've had the tornado and then COVID. A lot of lawyers live in East Nashville and Germantown. You know, they're not only dealing with COVID, but they're dealing with issues related to the tornado. So I think we're both going to be very reasonable in extending those scheduling deadlines. Now, I do want to say one thing about depositions. I would strongly encourage that at this point, depositions be taken by video. And I'm not talking about a video deposition as set forth in the rules. I'm talking about in the nature of a video conference. You know, being closed up in a courtroom with, you know, 4 or 5 other or more individuals could be an uncomfortable setting. So please, you know, lawyers, be safe. Think about doing things by video if you can.
Yeah, in regards to the scheduling orders, if the court has put down a scheduling order, I'm very disinclined to let the attorneys modify it. Although, as Judge Smith says, we're pretty liberal about extending scheduling orders through all of this. I know a lot of people have, because they may be more susceptible to the virus or have a loved one that they can't go out and risk catching something and bringing it home or staying home. So we're trying to be pretty liberal about that. I'm doing a lot of conference calls with lawyers adjusting their scheduling orders. So if you've got that issue, call us. We'll be happy. I've got time to do it. We'll make time to help you get your scheduling order rescheduled. But I'm still going to be pressing for people to move forward. And written discovery, folks, it needs to go forward. And as far as I'm concerned, I'm like Judge Smith. These depositions can be taken. You can make some adjustments. You can do them by telephone and conference call. There are a lot of ways to do it, but for goodness sakes, help these people get through their divorces. They need to get those things behind them, especially if they're children. So do what you can to keep the process grinding forward.
We have a question about alimony. With so much economic uncertainty, are you open to approving agreements between the parties to set alimony as a percentage of one party's income?
I think I'm going to let Judge Smith answer that. I think I know his answer. I know my answer. I'll let you go on, Judge.
Yeah, I think they probably need to start with the Court of Appeals asking that question. 36-5-121 is very specific on specific factors we have to consider. We can't just waive the statute and go with the percentage. That'd be great for us, quite frankly, you know, for the legislature to say that alimony is just a third of an individual's income if it's appropriate. But yeah, no, I don't think I don't think we can do that under the statute. Would you agree with that, Philip?
I do, and I've unfortunately got an irreconcilable differences divorce coming up maybe next week that they're starting off with a set amount, and then it's going to automatically modify later on, and the statute requires, once alimony is set, that there has to be a material change of circumstance, and the parties either have to agree on a definitive amount for a modification, or the court has to set it, but it can't automatically adjust. And that's what's happening when you got a percentage. Somebody makes less this month than they did last month, or they make less this year than they did last year, so it automatically adjusts. The statute doesn't provide for that, and I think the Court of Appeals would have a major issue with it.
Concerning parenting time, I know you have a standing order about how parenting schedules are supposed to be addressed during this time. We do have a question about circumstances in which one parent is being risky with social distancing or not social distancing, and whether or not that could give rise to someone's parenting time being suspended.
First of all, let me say the standard order Judge Robinson and Special Master Williams really worked closely on that. I had a little bit of input, but that order actually made the New York Times. It was discussed in the New York Times and favorably. So I want to commend both of them in putting it together. Nothing prevents someone from filing a petition to change custody with a request for a temporary restraining order. I mean, that just treat it the same as you would if a parent was abusing, narcotic drugs or something of that nature. And we'll take a look at it. And if it rises to irreparable harm, then there's a good shot of getting a restraining order.
In regards to the standing order, I appreciate Judge Smith's kindness, but in the interest of total disclosure, I think I stole most of it from the 19th Judicial District. There are a bunch of smart judges down there, and I think they put most of that together, and then we modified it a little bit. But having said that, I think one thing everybody needs to remember is that while both parties are parents, they can parent differently, and what's acceptable in one house isn't acceptable in another. If people, there may be certain standards of cleanliness or mask wearing and social distancing in one house and they're not in the other, it's going to be really hard to enforce some type of order on social distancing. And obviously taking small children to big crowds, hopefully people are smart enough, and if we have to, we can take action on that. But if it's different standards in each home, it's going to be really problematic. And so I think we're going to have to trust that each of the parents love their children. They may have different ideas about what's appropriate, and I'm afraid the law would recognize that there are two different households, and each parent can parent within some reason the way they want to in their home. So I'm really worried about people trying to come in and dictate to how the other parent's going to handle their household and what they're going to let their child be exposed to. I think it's going to be a problem.
The governor recently put down Executive Order number 26 that allows, or I guess relaxes the rules on remote notarization of documents. And we have a question about how that's affecting cases in which banks are not accepting quitclaim deeds that have been signed pursuant to that executive order, and how the court would deal with delays in executing quitclaim deeds as a result.
Well, I have to say, I've read that, and one of my court officers and I spent a period, what I thought was a pretty long period, trying to figure out exactly how that was supposed to work. And some parts of it seemed to be relatively clear, but then some parts did not. I will suggest to you, and a lot of lawyers do this nowadays, which I really appreciate. But quitclaim deeds, while they're a wonderful backup, and everybody ought to do them if they can, if you put the property description of the property that's being awarded to a person in the marital dissolution agreement, and you divest one party of their interest and vest it in the other party in the marital dissolution agreement, it works. And while following up with a quitclaim deed is always a wonderful idea, one way lawyers can at least cover themselves and make sure, even if they do a quitclaim deed, if there's a problem with it, you can still fall back on the contents of your marital dissolution agreement. But you put the property description and you put a clause divesting one party of their interest, investing all interest in the other party, that's a court order, and it has as much validity as a notarized deed. So attorneys may want to consider that just as a backup, but certainly go on and get your quitclaim deed if you can, and even if there's a problem with the notarization of it, you'll have the backup of the final decree of divorce.
And let me say, that was something that when Judge Robinson and I practiced together, that was something we did did often, but I would strongly encourage recording that final decree with the registry of deeds.
Yeah,
so
good
it
point.
notice to the world. And as far as the electronic notary statements, you know, there's a lot up in the air right now, and I believe probably that Chancery Court would be a good place to file a lawsuit to force the banks to comply with the statute. Would you not agree with that, Judge Robinson?
Absolutely. Yeah.
We can give you the phone number if you'd like.
What, of Chancery Court?
Yeah.
Yeah, or cell phone numbers too.
Yeah, right.
I want to take a quick minute just to remind everybody on this conference that if you have a question for Judge Smith or Judge Robinson, if you'll please use the Zoom group chat function to submit that across. And in the meantime, while we wait to see if we have some more specific questions, let me ask you both a general question. Have there been any silver linings in this situation for you, or is there anything that you're particularly grateful for in this uncertain time?
You know, I'll start with that. Let me say, you know, it's hard to call it a silver lining when people are, you know, have lost their jobs and you know, are losing loved ones. But we have learned some things, and I know one thing. I'm going to continue to use technology in the future, you know, video conferencing is I think go to on contested cases. You know, we do judicial settlement conferences, but I'm going to do more in the way of from a case management standpoint of status conferencing, and you know, see if we can cut down on some of the time. And a video conference is a great way to do it. So I think from that standpoint, the use of technology and you know, being forced away from the 50-year rule, I think it's been really good for us, and I think it's been good for trial judges across the state.
Yeah, I think we would have never ventured forward and tried to use some of the new technology if the circumstances hadn't forced that on us. And we've learned that we certainly can do some things on it and help something move forward. So the good news is that we now have these telephonic bridges that we can have different people calling in on, or the video conferencing as kind of a backup. I've told Judge Smith I was fearful that the lawyers would realize that if they could avoid driving downtown and paying that parking, and now that they've gotten used to that, they would never come back to the courtroom. And if I have to, I'll hit my video screen with a baseball bat, because it's, as I say, it gets kind of lonely up here. And we're ready for the lawyers to come back. I know Judge Smith and we both managed to stay busy, but I like to stay busy, and I feel like we're not, while there's a lot of work in trying to set up these motion dockets by video and this sort of thing that our staff is having to deal with, I feel like we're not being used efficiently, and we're not accomplishing as much, and I don't like that feeling. So I'm looking forward to getting folks back in the courtroom so we can make things happen.
You both mentioned technology in your comments, and we have a question about your thoughts on using video conference capabilities to display exhibits in your courtrooms and contested matters.
The truth of the matter is, well, I was the last one to get, I have a big TV screen like Judge Smith does on the wall of his courtroom. I was the last one to get that because my fear was that the lawyers wouldn't utilize it, and it would just be a waste of the taxpayers' money and slowly slip into obsolescence because it was just never being used. I have seen it used very, very effectively, especially if we're showing a video. I know Marissa Russ used it very successfully in a custody case where you could have one parent tell what happened, but until you saw it and saw how vitriolic the behavior of one parent was, it really made a big difference. So it certainly can be used. I don't think it's particularly good though on things like exhibits, because I want that paper exhibit in my hand. I want to be able to write notes on my copy of it because I keep my separate set of exhibits from separate from the ones that the court officers are keeping, because I write notes and circle things, and then I go back and look at those when I'm working on rulings. So if you have a jury and the jurors are not all going to have a copy of the exhibit, I think they're great. But on a bench trial where in domestic cases have lots of, I mean, we have tons of exhibits in these cases, tax returns, bank statements, this sort of thing. I don't think there's much substitute for having the real exhibit where you can see it, look at it, and having it up on the screen for a few minutes and looking at it, and then it leaving the screen and me not having a paper copy of it to go back and consult is problematic. So if you're going to do it that way, please give this old judge a copy of the exhibit, because I'm going to keep it and I'm going to write notes and that sort of thing on it. What's your thought, Phil?
You know, we have a document cam in the courtroom, but I absolutely agree with you. In a jury case, it's great. In a bench trial, I mean, you know, I'm looking at the exhibit, the witness is looking at the exhibit, the parties are looking at the exhibit, and both lawyers. It's really a little cumbersome. I mean, it's here if you want to use it, but I find that it takes a lot of unnecessary time in dealing with it.
Yeah, I totally agree with that. And Judge Smith, right, we have the equipment for this up here. I don't know how to use it, but I have people that know how to use it. If you want to use it or you want to show a video, call us and make arrangements to come by the afternoon before. And my people, who are great, they will do anything they can to help you. And then that way, when it's ready to use it, you're all set up. You know exactly what you're doing. They can help you and get it on, and we get it done. What is very upsetting to me is where we're trying to move through these trials and somebody wants to use the equipment, but we have 15 or 20 minutes trying to set it up, and then we get into it, and then they can't make it do something they thought it would do, and then we've wasted a lot of time. So if you want to use it, and I don't mark people down for using it, let us know. We'll help you try to get it ready to go. But if it's going to take a lot of time, I'm not going to be happy about that. We need to, again, help these people get their divorce case done.
We have a question about child support issues and child support modifications in cases where people have lost their jobs or are experiencing financial difficulties because of the pandemic. Have you seen a lot of those cases recently? And I guess with everyone wanting to be optimistic that those financial difficulties might be temporary, what guidance can you provide to lawyers about how to handle those kinds of modifications?
I just actually had it on a pendente lite motion this morning. You know, we have to be cognizant of it. I mean, it's something that under the old law, back prior to 1990, it would have been a substantial material change in circumstances, I think. But if there is a 15% significant variance and it justifies a modification of child support, then I think it's certainly fair and right to award the modification. Now, if somebody has done something intentionally, you know, quit a job before all of this came about, then that may be a different story. But no, I think we have to be cognizant of what is happening. Like I say, it's not just COVID. It's the tornado too. I mean, and now the economic downturn, we're going to see, I think, effects from the economic downturn for a long time to come.
Yeah. One thing I want to point out, please remember, the original guidelines were designed to make the modification of child support easy. You just needed to get a certain set of numbers, parties' incomes, and this sort of thing, and you put it on the calculator, and it showed you exactly if there was a 15% variance and what the support ought to be. We tend to make it complicated because many times we're trying to resist where somebody has had a downturn in income and the other parent doesn't want to lose a certain amount of child support. I would suggest to please tell your clients, be reasonable. If somebody's lost their job, and certainly they're not refusing to work, then they're entitled to reduction. And if you have, for God's sake, get their petition filed right away, because I almost always make it retroactive to the filing of the petition. There are some exceptions to that. But people need to, they need to be reasonable and understand that the other side can't pay the same amount. I do have a concern, though, about people who have lost their job and their job is now available for them again, but they say they don't want to go because they're fearful of the virus. No matter what we do, no matter what the politicians say, this virus is out there forever. It's going to be there. And sooner or later, probably we're all going to be exposed to it. Our hope is that we'll have a treatment and maybe a vaccine. But there has to be an end of us hiding in our homes. So if you got an opportunity to go back to your job, social distance, get you a mask, do those things you need to, but try to get back to work because your kids deserve it.
We have a couple of last questions because we're coming to the end of our time together. They have to do with the standing order. Firstly, for parents who are at the beginning stages of a divorce and are exercising parenting time or have an agreement about how they're going to exercise parenting time, can lawyers properly advise their clients that paragraph 1 of the standing order regarding COVID would apply to them?
I don't think either one of us have a copy of the standing order, and we don't know what paragraph 1 is. But I'll answer for Judge Smith. He says no.
I can't recall what paragraph 1 says either. So
I'm sorry, I'm at a disadvantage, Ms. Baker.
Yeah.
I am a little bit too, but I might get a little more information if we wait a minute. Let me ask you a second question. If one parent tests positive for COVID and has to quarantine away from their children, are you requiring the parent who tested positive to provide a negative test result before they can resume their parenting time?
My thought is if they're quarantined 14 days and they don't have any symptoms of the virus, in a perfect world, we would want that negative test. The problem is that sometimes, and we still don't know, I don't know what the real turnaround is on those tests. I've heard everything from they're going to have home tests where you can get it done in 5 minutes to where it still takes a week or more. We had that issue in my office, and it took a week before we were able to get the test results back. So if someone's been quarantined for 14 days and they have no symptoms, I'm probably going to accept that. If there's a quicker, easier test that we come up with, then that would be great. And in an abundance of caution, maybe that's where we need to go.
I agree with Philip on that. I mean, it would be hard for me to really believe a parent who was still showing signs of COVID would want to expose the child to that. I think if it's been 14 days, they're not showing any symptoms at that point, then probably would strongly consider allowing the parenting time to resume without the showing of the test.
You'll be pleased to know that the domestic bar has come through, and I now know that paragraph 1 of the standing order suspends parenting time for 14 days if the child, a parent, or an in-home sibling is diagnosed with COVID. And it seems that applies to court-ordered parenting time, and the question is whether that would also apply to agreed-upon parenting time.
I'll let you take that one.
Yeah, first of all, when we put the order together, we did think about these things, and certainly we don't want children exposed. So if the child or a parent or a member of the household has the virus and the child is with the other parent, then that's where the child needs to stay. The problem with the child, if you have someone coming down with the virus in the home, removing the child and putting it somewhere else, the child may be carrying it and it's going to another family that could be infected by it. But I absolutely would enforce that and want the child safe. The good news is, from what we're hearing, the virus doesn't seem to be adversely affecting younger people too much, although we're all aware of the British have come up with what they're seeing are problems with some in a very limited number of cases. Children having, small children having some additional symptoms that are difficult. But as far as I'm concerned, I'm gonna enforce that. I guess if the parties are agreeing, doing something by agreement, and one party or the child gets the virus, I think the 14-day quarantine and the child not going back to the parent or the household that has it certainly ought to be observed. But in the court orders case, that's exactly what that standing order was about, to try to protect children.
Let me say, just as a follow-up, it's always a problem when the parties have got an agreement and it's not been reduced to writing and adopted by the court via court order. Certainly, I think that parents should recognize that, but it's always hard to, quote, enforce something that is not a court order. So I would encourage everyone, particularly through this time, when they have an agreement, go ahead and reduce it to a court order, an agreed order.
I'm not going to enforce just an agreement between the parties. That's that. Judge Smith is right. If you're changing it, doing something different, great. Put together an agreed order and sign it. But I'm not going to enforce it, because enforcement entails contempt. I'm not putting anybody in jail because they broke some agreement that they had between the two parties. It's not a court order. It's not contemptible, and I don't think it's enforceable.
We have come to the end of our time, but I want to give each of our judges an opportunity to share any closing thoughts that you have with the members of the bar that are on this conference.
The only thing I'll say, folks, I think the lawyers that we've been dealing with in court are doing a great job and working with our staff wonderfully, and we really appreciate that. And I'll just reiterate for the third time, I'm looking forward to seeing y'all all again in the courtroom as soon as we can. So y'all stay safe and have a good weekend.
You know, I will echo what Philip is saying, Judge Robinson saying. We're both lawyers at heart. I mean, we trial lawyers. We did this did trial work for the majority of our career. People we like to be around are lawyers, and I'm missing the lawyers. I'm missing seeing them in court on motion dockets. So I want everybody to come back and everybody to appear on the dockets one of these days in person. I hope that will happen. And in order to do that, please, everyone stay safe and be careful.
On behalf of the Nashville Bar Association, and I'm sure on behalf of everyone who's on this call, we thank you so much for your leadership during this time and for helping us all get through it by making adjustments and modifications, and also by making yourselves available to answer questions today. And we hope both of you stay safe as well. And now we'll bring this town hall to a close.
Well, Laura, thank you for putting this together.
Thank you.